Hello. Nowadays, the idea of abusive procedure is rather popular, for better or worse. Whenever you are in a litigation, you might face the situation when the other party abuses the procedure in a sense of using it to cause some delay or to distort the judicial system or just to exhaust you out of litigation, for example, or cause you harm in the sense that, again, you have to participate in litigation, which is from the beginning is like useless and unfounded and whatever. Or you might see yourself to be accused of using or abusing the procedure in order to cause harm to another party or to the judicial system. So in both situations, if ever you intend to participate in some kind of litigation, it might be a good idea that you understand what is called abusive procedure and how to avoid it, and what kind of penalties might be there if, unfortunately, you commit something, or if your lawyer does, or if the other party does, or if the other party's lawyer does altogether. So, well, it happens. It also happens, unfortunately, that the very notion of abusive procedure is used in an abusive manner when let's say the other party is bringing it up in order to cause you harm, and again, to delay or to overcomplicate the litigation and to abuse the judicial system. So, in a sense, abusive procedure is a notion, and it's a tool, and it's a situation, and it might be even a fault in itself. So to go a little bit further into that, let's first have a look at the famous Article 51 of the Code of Civil Procedure, which follows the previous Article 54.1, as far as I remember, of the previous Code of Civil Procedure, and which outlines where the abusive procedure can be found, and what it is, and what is not in some places. There are following articles, actually, but the discussion always starts with the Article 51. What do we see in this article? First of all, and that's sort of new, as compared to the previous legal provisions, the abusive procedure, the idea of abusive procedure, the conduct which is abusive from this point of view, might be found regardless of intent, which means that a defense like I didn't want that, I didn't know that, I was not going to do exactly that, is not a defense anymore. And whenever you're accused of the abuse of procedure, if you, as opposed to what was happening before, if you try to prove that it was not your intent, it might be not a good defense, actually. So regardless of intent, if in reality, in fact, the legal application, the court application, one of them, or the originating application or something in the course of the preparation to the trial, or in some interim hearings, or something going on during the trial, if it is appeared to be clearly unfounded, in a sense that you knew or should have known that neither the facts nor the law support your claim, your position, then it might be seen as an example of abusive procedure. Mostly it happens when you go to court without consulting a lawyer. Why? Because many people justify their claim in like common sense or our own understanding of justice, like our commonsensical everyday understanding of justice, usually fed by some literature, some Hollywood movies, or some TV series like Suits, for example, or some experience with some judicial system abroad, like again United States or United Kingdom or Europe or even some other province in Canada, again multiplied by our own understanding of how the law should be, or some advice of our neighbor or friend, or just like burning sense of justice or something like that. So basically, when some people feel that litigation is justified, but for whatever reason, usually out of like financial considerations, they prefer not to ask for lawyers' help. Those people might find themselves held like culpable of abuse of procedure because they in reality bring an unfounded claim, like not founded in law, in particular law, or again as applied to particular facts. Very often it happens when like we know our story and how we understand it, but we don't have enough evidence, or our understanding is wrong, false, not proven by evidence or logic again. Or sometimes we think that something should be punished, while in reality, at least by the letter of the law, it should not be. Of course, unfortunately, sometimes even with the use of a lawyer, you can appear in a situation when you brought up an abusive claim to the court, to the judge, especially when your lawyer follows your lead and tries to please you in your outrage of what's going on. And honestly, I would suggest that if you see that your lawyer is cautious about your claim and is not like really happy to proceed, it might be a good sign that you should hold your horses and think again, because eventually it's not that you only risk that you lose your case before a judge, you also risk that you might be, for example, ordered to pay the legal expenses, the lawyer's expenses of the other party, if your claim was clearly unfounded from the beginning. And if you continue with the repetition of bringing more and more claims like that within the same litigation or connected litigations, it might be seen as frivolous, for example. Interestingly, like if we see the first regardless of intent, and then third, intended to delay, we see some contradiction. And it will depend on the judge, actually, how it will be interpreted, whether it should be seen as objectively causing a delay, or if it should be seen as this delay was really intended, that was the goal, that was the cause that you worked for. But still, the longer the delay caused by those repetitive or overcomplicated procedures, the more the chance that this would irritate the judge. Again, there is no guarantee, of course, because at the end of the day, the final say is always with the judge, but at least the risk is there. When it comes to vexatious and quarrelsome conduct, it's usually driven and fueled by emotions. When there are a lot of, like negative wording, like accusatory wording, a lot of emotional and negative emotional stuff, in your text and in your applications without particular cold line of logic like 1, 2, 3, 4, this is proven by this is proven by this. Like often when this is the way you use the judicial system, and usually it happens when you seek that the judge would tell you that you are a good person and the other party is a bad person. Basically, when you seek moral judgment from the court, very often, especially when you're not helped by a lawyer, who would probably limit this outrage of yours again. When you bring this to the judge, when you bring this to the court, especially if it's a civil court, then you might be disappointed by the fact that normally the judges are not there to bring up like moral judgments, be it a divorce litigation, be it a contractual litigation, be it a trouble de voisinage, the neighborhood problem litigation, be it a situation between parents and children, grandparents, parents and children, where there are a lot of like, personal emotions are involved. The judge is not there to morally educate people. The judge will look into the legal claim, the legal evidence, and the legal outcome, leaving your family relationship or your personal relationship out of it. But if this moral judgment was the main cause for you to go to court, which would mean that your claim might be clearly unfounded, and that it might be so much hostile and emotional that it would seem vexatious and quarrelsome, because you would work like again and again trying to bring it up again and again, even if it's already dismissed by the judge. And sometimes you even go as far, never do that, as to accuse the judge himself or herself of being duped or God forbid, corrupted or something like that, which unfortunately happens when people don't have what they want to have. And if you go to court, or the other party goes to court, with the sole goal to stigmatize the other party by the judge, and when the judge does not cooperate, the temptation to see the judge as the part of the evil emotionally sometimes is so high that this goes into your texts. You accuse the judge altogether with the other party, and there your conduct has a lot of chance, a great chance to be seen as vexatious and quarrelsome. So again, if you understand that at least in a huge part your claim is emotional and moral as opposed to like legal and civil, then you might need some time to cool down and to reanalyze what you're bringing to the court. Again, sometimes your claim is simple and not so expensive, but you want to make the other party suffer. And because of that, you want your lawyer or yourself to just shoot every gun possible, to bring up every complication, like every trouble possible, especially in the situations when you see a lawyer as your gladiator or as your as your own mobster, let's put it this way, to punish the other party. In such a situation, well, as long as we are still within the framework of civil legal procedure, you might see yourself or the other party, depending on who is in such a stance, who is using the procedure this way or abusing the procedure this way, you might see that where like one simple application is enough for one simple judgment, there are a lot of applications, there are a lot of accusations, there are a lot of claims. The paperwork is just becoming fatter and fatter, your folders, bigger and bigger. And it does not only hurt the other party unnecessarily from the legal point of view, it also overloads the judicial system, which is, believe me, already overloaded. So when this excessive and unreasonable use of procedure, meaning of documentation, of calling for another hearing, for interim judgment, something like that, when it's seen by the court, when it's seen by the judge, chances are that the court, the judge, would see it as abusive and just hold it against you. Or if it's caused by another party, then hold it against the other party. Again, as you probably saw, heard, or can imagine, there are situations when, unfortunately, but there are, when somebody goes to court not in order to really protect their rights or not to really ensure that their justified legal claim is seen, not to have their chance in court, again, for a just cause, but from the beginning, just to make the other person pay money to lawyers, maybe make them fail from going somewhere abroad for vacation, or to make them miss some business opportunity. So the idea is from the beginning that no matter the result of the litigation, the very fact of litigation will cause harm to another person. And if it becomes clear and evident, if it's proven before the court, again, the court, the judges might see it in a very negative way, and it might backfire a lot. Sometimes, often when you're in defense or the other party are in defense, but sometimes not, the procedural complications, because if there is a desire, there is almost always a chance to complicate the procedure, is used in order to prevent the court, the judge, to render a judgment. Because let's say the other party knows that if it goes eventually before the judge, they don't have good argument on the merit. They don't have a good defense. They don't have good evidence. So what is the chance? The chance is to complicate and overload and bring more and more to the litigation in order to delay and delay and delay and delay. Here's the intended to delay, by the way. Or to just distract the attention of the court, hence bringing some, again, unfounded counter claims and so forth, so that the case, which was rather clear from the beginning, becomes not only complicated, but very often in such a situation intended for further appeal, and maybe even appeal after appeal. And by this, the party who is expecting that justice be done, this party either is exhausted from the litigation, because many people simply cannot just support themselves through years and years and years of litigation. So they might be exhausted from litigation, and therefore the ends of justice won't be served. Or at the end, the very presentation of the initial problem will change to something like barely comprehensible, which, if we're all lucky, will be disentangled by the judge. But again, situations are different. And if this is proven, basically if it's proven that a lot of procedural steps are only overcomplicating the case without serving the needs of justice, without actually adding something to the argument. For example, more and more expertise, expert opinions are ordered, more and more pretrial examinations are held, more and more unnecessary and not leading anywhere evidence is submitted and then again examined, and so forth and so forth. More and more interim applications are brought before the court. This altogether eventually might be seen as an attempt to defeat the ends of justice by preventing the judge, the court, from seeing the actual claim and the actual evidence. And that, again, can be seen as abusive. Finally, as you probably noticed, we discussed the question of defamation a lot here in this channel, and it's not rare, it's not unusual when somebody sees somebody else's speech or text, whatever, offensive, regardless of the actual value of those words. Sometimes it's a valid cause for litigation and defamation, but as you can imagine, the very idea of defamation, and especially if you're like a big firm or big political party or simply a rich person, and the other one who is trying to bring some news about you, truth about you, public, against your interest, but still, is not as well supported, then there might be a temptation to simply gag that person by filing one defamation lawsuit after another. And even they're lost, even if that person wins one after another, it will cause that person a lot of expenses, not to mention the stress and suffering. So if it is shown, if it is proven that some kind of litigation directly in defamation or indirectly, like that person who is not understanding the implications continues to bring up something to the public while having some debts, for example, or some financial problems, or some rent, commercial rent problem or whatever, and then suddenly those issues become the points of litigation against that person. So indirectly, just to shut the person down, somebody uses all the available legal means to make that person's life miserable. Even then, but of course in case of defamation, there might be a situation when the court sees it as abusive, because the real goal is not to bring some justice, but to fight against the freedom of speech, particularly when it's valuable for public debate. So when something like that, like I've just described, happens, again, there is no guarantee that the court would see that there is a issue of abuse of procedure, because again, when we are partial, when we are on some particular side, we might see every move of the other party as abusive. And unfortunately, there are a lot of situations when the parties just have a not so much in a litigation from the beginning, but a lot of claim of abuse from both sides, which, as you can see from this list, might be abusive itself, because it might be clearly unfounded, it might be intended to delay, it might be vexatious and quarrelsome, it might be seen as excessive use and unreasonable use of procedure, it might cause prejudice to the other party, it might be an attempt to defeat the ends of justice, even to shut up the other party. So whenever you think of coming into litigation, or whenever you analyze what you require from your lawyer, or whenever you analyze what your lawyer suggests to you, or whenever you see what the other party is doing, keep in mind that there might be a question of abuse of procedure. Finally, I would like to draw your attention to this famous case. And if you're really interested, you might see other cases where this one is cited, where, particularly in paragraph 65 and following, the judge is discussing how to analyze the situation, and then further what can be done if abuse is found. Just to sum up, you might simply lose your case. You might be forced to pay for in full or for some lawyer's expenses of the other party. You might be prevented from bringing some evidence before the court. But basically, the judge has significant rights to punish the abuse of procedure, and you might even be ordered to pay some additional money, like in punitive damages, for example, to the other party because of this kind of behavior, and vice versa. The other party might be ordered to do to pay that money to you if the other party committed anything like that. So going back to the question of abuse of procedure, whenever you think, or whenever the other party thinks, that however good you have arguments on the merits of the case, that this is a good justification to make the other party's life miserable from the procedural point of view, that's usually wrong first, and that might be a reason to see your behavior as abusive from a procedural point of view. So even if you have all the arguments, even if you have all the rights as you think, be cautious and do not use procedure in an abusive manner, at least in order not to spoil your actual case. Thank you and have a nice day.